Okay, it says that we're recording, so we can go ahead and get started. Hear ye, hear ye, hear ye. The Texas Court of Criminal Appeals is now in session. All of those with matters to present shall come forward to be heard. Now to you, presiding judge.
We are ready to hear argument in cause number 15-20-00420CR, Lucille Bluth versus the state of Texas. You may proceed.
Thank you, Honor. May it please the court, my name is Alicia Mponde, and along with my co-counsel, Ms. Sarah Baumgardner, we represent the appellant in this case, the state of Texas. At this time, Madam Presiding Judge, we would like to reserve 2 minutes for rebuttal. Thank you. There are 4 issues in front of the court today, and I'll be addressing the first 2, which are why the governor has improperly voided the Orange County Health Ordinance and why the governor's 4th emergency order violates the pardon clause of the Texas Constitution. Later, my co-counsel, Ms. Baumgardner, will address the 3rd and 4th issues, which are why the blood alcohol content results should be admissible and why the evidence was sufficient to support the jury's conviction of an assault charge. Your Honors, this is a case about preserving the delicate balance of power between the branches of our state government. The governor's actions in this case exemplify the very overreach of authority that the drafters of our state constitution were trying to prevent. And with that in mind, we are asking this court to reverse the judgment of the 15th Court of Appeals for 3 important reasons. 1, the governor should be required to explicitly state how a statute he has chosen to suspend under the Texas Disaster Act hinders him from handling a catastrophe. 2, the Orange County Health Ordinance was not preempted by the governor's 3rd emergency order because he cannot and has not stated how the statute he chose to suspend hinders him from handling the pandemic. And 3, the governor's moratorium on confinement in his 4th emergency order constitutes a commutation without board approval, therefore violating the Texas Constitution. As to my first point, the governor should be required to explicitly state how a statute he has chosen to suspend under the Texas Disaster Act hinders him from handling a catastrophe.
Can I ask you a question about that?
Yes, sure.
It's my understanding that Government Code 418.016A doesn't specifically require the governor to state his reasons. So why should we do as you're asking us to do and impose that requirement sort of outside of the legislative determination process?
Yes, Your Honor, you are correct that the language of the statute does not explicitly state the governor has to state his reason. However, the legislature did include a condition on this authority and that the governor has to have a reason. So the court should—
I'm sorry, let me interrupt you there. I'm pretty sure we all knew that COVID was a reason. And because at the time of these, the issuance of these orders, I don't think anyone in the country knew exactly how they were going to handle it. So does that make any difference here?
Your Honor, we don't believe that makes a difference here, mainly because when considering, as you mentioned, the unprecedented nature of this pandemic, we don't believe that the governor even still had a reason for instituting this 3rd emergency order. And to more specifically answer not only your question, Your Honor, but the one previously posed, the governor needs to explicitly state what his reason is for suspending statutes, 1, so that this court can ensure that he is complying with the requirements of the statute imposed on him by the legislature, that he actually has a reason that is hindering him from handling the catastrophe. But 2, Your Honor, so that we know what that reason is, so that we can hold him accountable to that reason, not only this court, but also the legislature when considering potential changes to the Texas Disaster Act in the future, or the voters of Texas who have a right to know how the governor and why the governor made these choices in these emergency, unprecedented circumstances. However, even still, again, we don't believe that the governor had a reason for suspending the statute in this case. And as Justice Rodriguez emphasized in her dissenting opinion in State versus El Paso County back in 2020 from the 8th Court of Appeals, the governor did not, or the legislature did not intend for the governor to assert this executive power under the Texas Disaster Act in such a way that he is able to make these decisions without having to explicitly explain why he is suspending certain statutes, as the legislature did impose many checks and balances on the governor's authority under the Texas Disaster Act. And the problem with the interpretation that the 15th Court of Appeals seems to have taken in their majority opinion is that those checks and balances can't be placed on that power. This court is responsible for making sure that at the very least, the governor is complying with the requirements of the statute, that he have a reason. And there's no way for us to know whether or not he had a reason if he's not required to explicitly state what that reason was.
Well, assuming that we did require him to explain his reasons, by what standard would we judge the adequacy of his explanation?
Well, Your Honor, we would argue that at the very least, it needs to be a plausible reason, but specifically using the language of the statute, a reason that is hindering him from handling the catastrophe. So, for example, the governor in his second emergency order did state that the reason for expanding the capacity of local businesses was so that he would be able to preserve the economy of the state of Texas. And so that was a perfectly acceptable explanation for that order. However, Your Honor, in the third emergency order offering absolutely no explanation, there's no way for us to know what the governor's reasoning was or if he even had a reason.
Could the reasoning from the second order have carried over?
No, Your Honor, especially when considering particularly the difference between the second emergency order and the third one. In the second emergency order, it makes perfect sense the governor would expand a capacity of certain local businesses so that he could properly preserve the economy of Texas or make sure that those economic interests are met. However, and that almost brings me to my second point, in the third emergency order, the governor suspending counties' ability to enforce mask mandates does not make sense when considering that these mandates, as he even admitted, if we look to page 9 of the record in his fourth emergency order, help prevent the spread of the coronavirus pandemic. So by allowing for counties to enforce these mask mandates, the governor ultimately would be making it safer for people to go out in public or visit local businesses. But instead, the governor in his third emergency order suspended counties' ability to enforce these mask mandates.
Well, but because the legislature didn't impose this requirement of stating a reason, isn't it sort of activist of us to sort of do that for them? Don't you think that it's possible that they considered the possibility of imposing a requirement of stating that reason so that it could be reviewed versus not doing so, and chose not doing so over requiring him to state those reasons?
Well, Your Honor, 2 points to your question. One, we don't believe that it would be inappropriate or activist of this court to interpret the statute in the way that, again, the legislature likely intended for it to be interpreted when they placed those conditions on that authority. For example, that if language within the statute stating that he has to have a reason that hinders him from handling a catastrophe. So simply we're asking this court to interpret the statute in the only reasonable way that would make sure that this court can enforce those checks and balances by making sure and holding the governor accountable to having a reason by requiring him to explicitly state what that reason is. But second point to your question, Your Honor, and I think it raises a more important public policy implication here, is that, again, the governor is an elected official. And so it's important, and as I'm sure the legislature also intended, that voters and the legislature alike would be able to know whether or not the governor is abusing his power under the Texas Disaster Act. For example, the legislature can't make any changes to the statute or know what changes are necessary. As Your Honors mentioned, this was a very unprecedented and unique emergency circumstance that our state was experiencing throughout the time period of the pandemic. And there's no way for the legislature to know whether or not these changes need to be made if the governor is not expected to state explicitly what his reason was for suspending statutes under the act. But
Counselor, if I may, it's similar to Judge Hervey's question, and that is this: if there's not a statutory requirement that the governor put in the rationale within these orders, it's similar to what Judge Hervey was kind of alluding to. Are you saying we don't have the capacity to kind of aggregate all of the orders to infer what the rationale ultimately was?
No, Your Honor, and here's why. When looking at, for example, the time difference between the second order and the third order, it was about 19 days after the governor issued order number 2 that he issued the third emergency order in this case. And so circumstances change. Throughout the pandemic, guidance regarding masks, for example, developed further. And so it is important that we know and recognize why the governor made these choices, especially when considering, again, the fact that he chose to suspend county's ability to enforce mask mandates, even though, as he shortly admitted after his third order, they are effective in preventing the spread. So there's no reason why being able to enforce a mask mandate would prevent him from handling a catastrophe. And also, Your Honor, in fact, raising the issue of the governor trying to put this one-size-fits-all solution on a problem that affected counties across the state in such unique ways. On June 20th, 2020, when the governor put this third emergency order in place, for example, according to the Texas Department of Health and Safety in Harris County, there was 1 case for every 239 people within the county. Compare that to El Paso County across the state, where there was 1 case for every 19 people within the county. So this demonstrates how differently this virus not only affected counties across the state, but amongst different population sizes, which is why it is important that county judges have the authority and the ability to handle this pandemic and this emergency circumstance in a way that is best appropriate for their own communities.
So would the counties have to have an explanation for their policies?
No, Your Honor, because ultimately the counties would not be doing something such as suspending a statute like the governor did in this case. And that is also another important point here.
Counsel, let me interrupt you. I think you said you have a second issue. You are down to under 3 minutes, and I'd like to hear you address it if you can.
Absolutely, Your Honor.
Thank you.
Moving on to my last point, the governor's fourth emergency order did constitute a commutation without board approval, therefore violating the Constitution of the state of Texas. Now, Judge Newell, in your opinion in Van Dyke versus State back in 2017, you wrote about how commutation is defined as a reduction in punishment. And that's exactly from one punishment to a less severe one, which is exactly what happened here with the governor's fourth emergency order. Ultimately, the governor was trying to ensure that people who violated mask mandates would no longer be incarcerated for them. And now Ms. Bluth is trying to use that fourth emergency order so that she does not have to face the punishment that she was rightfully given for violating her local mask mandate and committing the offense that she committed in Orange County.
Counsel, you're talking about situations, though, where the legislature has enacted statutes involving a punishment and a punishment range. And here you're talking about an executive order issued by the governor that imposes a punishment. Is there a distinction that we need to be aware of when considering this issue?
Yes, Your Honor, especially when considering the fact that the executive, the governor's pardon power is very limited under our Constitution. He has to first receive that board approval before doing so. And in the way that this order was written, in looking at form over substance, the effect of this order was that he would allow for people like Ms. Bluth to receive less severe punishments for committing these offenses. So ultimately, the governor's actions in this case, while it may not have been an explicit commutation or a traditional commutation, had the same effect as one, which is why it is a violation of the Constitution, because again, he did not receive board approval and comply with the limitations placed on his authority to commit these types of acts.
Well, Counsel, did the governor even have the authority to issue an executive order that contained within it a punishment such as prison time?
Your Honor, I see that my time is about to expire. May I answer your question and briefly conclude?
Yes, please.
Yes, you may.
Thank you, Your Honor. No, Your Honor, in that the governor's order here simply suspended the statute that would allow for incarceration. So while if he had provided an explicit reason, that may have been appropriate. The governor wasn't necessarily issuing an order here where he was issuing a punishment, but if he had, that also would be inappropriate due to his lack of authority under the Constitution. And it is for these reasons that we are asking this court to reverse the judgment of the 15th Court of Appeals. Thank you.
Thank you, counsel.
Madam Presiding Judge, may I proceed?
Please do.
Thank you. May it please the court. My name is Sarah Baumgardner, and as Ms. Mpande said, we are here today on behalf of the appellant, the state of Texas. I will address the third and fourth issues before this court. The third is that the trial court properly admitted evidence of Ms. Bluth's blood alcohol content, or BAC. And the fourth is that when viewed through the proper lens, the evidence is sufficient to support Ms. Bluth's conviction for felony assault. Your Honors, it's a fundamental principle in American jurisprudence that a reviewing court cannot overturn determinations properly belonging to the trial court merely because the appellate court happens to disagree with the final result. But Your Honors, that's what the 15th court did in this case. Allowing that court's decision to stand would permit a reviewing court to act as a 13th juror and allow Ms. Bluth to escape accountability for actions she does not even deny. In that light, Your Honors, there are three reasons we ask this court to reverse the 15th Court of Appeals and reinstate Ms. Bluth's convictions for both public intoxication and felony assault. First, Ms. Bluth cannot have a reasonable expectation of privacy in her BAC information, not only because she unequivocally consented to the blood draw, but because this court has held that even under HIPAA, no reasonable privacy expectation exists in this situation. Second, even if the court believes that Ms. Bluth does have a reasonable privacy expectation here, applying the exclusionary rule in this case would be useless because the officer engaged in no deterrable conduct. And third, because the definition for physical pain is the threshold for physical pain in that definition is quite low, the officer's unequivocal testimony that he suffered pain is sufficient to support the conviction for felony assault. So turning, Your Honors, to my first point, that Ms. Bluth can't have a reasonable privacy expectation here. Your Honors, this first point is really about whether the Fourth Amendment even applies. And under the privacy theory that we're operating under in this case, the defendant will have a reasonable expectation of privacy and the Fourth Amendment will apply if two things are present. First, she has to have an actual subjective expectation of privacy in the place or the thing that was searched. And then second, society must be prepared to view that expectation of privacy as reasonable. That's originally from the decision United States versus Katz from 1967. Now, I'll speak to that subjective prong first, Your Honors. We see in the record at pages 7 and 8 in this case that Ms. Bluth gave affirmative consent to this blood draw when Nurse Gomez asked her for it. I'm going to quote her words from the record now, Your Honors. When asked, she said, "Take it, see if I care, run whatever tests you want." So that's unequivocal consent to that blood draw. Now, we understand. Yes, Your Honor.
Does it matter at all that she might not have had the ability to formulate consent? I mean, we know she was intoxicated, and does that matter?
Your Honor, it would matter if she wasn't able to form the consent due to her intoxication. But if we examine decisions like Ramos versus State from the Fort Worth Court of Appeals in 2003, we see that even though she was intoxicated, she still had the capacity to form voluntary consent. In Ramos, the defendant was taken to the hospital by the officer and asked for a blood draw there by the officer, and she gave affirmative consent. And then on appeal, she tried to contend that her consent wasn't voluntary. But the Fort Worth Court of Appeals said it was voluntary because it looked at all the surrounding factors and determined that she still had the capacity to give consent. On the one hand, she had glassy bloodshot eyes and she was slurring her speech and she smelled a lot like alcohol. Those are very similar facts to the ones we have in our record at page 27 about Ms. Bluth. But on the other hand, the defendant was at a hospital, which the court held or said wasn't a coercive environment. It said that she wasn't under any kind of threat of physical force or duress. And then she was also able to have a conversation with the officer, which indicated that she could understand other people and they could understand her. We have those very similar. Yes, Your Honor.
Isn't it also true, though, that when she was allowing the hospital staff to make the blood draw, she probably wasn't anticipating that they would then go and take that information and deliver it right over to the police, given that she was in a hospital environment being treated for, the injuries that she sustained. And it's just hard for me to understand how you can make the jump to say, well, we don't need to suppress this evidence, even though it was gathered and by a private citizen, but then divulged in violation of, statutory law that makes that type of information private.
Judge Urey, my answer to that question has two parts. Preliminarily, the record is silent about whether Ms. Bluth did have the subjective belief that would be given to the police. We'll point out, though, that Officer Tesfaye was present the entire time and that he's the one that drove her to the hospital. That's in the record at page 7. But to speak to the substance of Your Honor's question, let's assume momentarily that Ms. Bluth didn't have, had actual subjective belief that there was no way this would be given to the police. That's not relevant to this court's disposition of this case in light of the third party doctrine under the Fourth Amendment. Now, as Your Honors are well aware, what that doctrine says, as the Supreme Court first articulated in United States versus Miller in 1976, is that when the defendant has voluntarily given information to a third party, the defendant has assumed the risk that their confidant will disclose that information to law enforcement. The defendant has also effectively surrendered any privacy interest that she could have there because she's the one that made it no longer private. So Judge Urey, even in a situation where Ms. Bluth didn't have the subjective belief that it would be given to the police or subjectively believed that it wouldn't, the test under Katz is conjunctive. The defendant has to show both prongs of that. And if she can't show both prongs, the subjective and objective one, then she doesn't have a reasonable privacy expectation. And any subjective expectation of privacy isn't objectively reasonable in light of the third party doctrine. And Judge Urey, you also referenced the statute that might give us a generalized expectation of privacy in our medical records. And of course, that's HIPAA. And I'll speak a little bit to HIPAA now, if Your Honors would like. HIPAA, well, but to speak about that first, I need to discuss, go back in time a little bit, if you will, and talk a little bit about this court's, yes, Your Honor.
Before you go there, just for my edification, who is the confidant in your comparison to the Supreme Court case?
Your Honor, here it would be St. Walter's, like in Miller, where it was a bank. Here it would be the hospital St. Walter's, which is why HIPAA comes into play, Your Honor, because we know that as this court has said in State versus Hughes from 2016, that as a society, we may have a collective expectation of privacy in our medical records in general. But in Hughes, the court explained that in the very specific situation that we're dealing with here, then HIPAA doesn't give the defendant a reasonable privacy expectation. And to explain why, I have to revisit this court's decision in State versus Hardy from 1997. Sure. Now, sure, yes, Your Honor.
Just for clarification, so you're saying that the hospital is the confidant?
Your Honor, yes. Yes, Your Honor, that the hospital, it would be the third party in this situation, just like the bank was in Miller.
Well, counsel, let me ask you a question.
Yes, sir.
Does it matter how the police get this information? Like, what if they break in the middle of the night and rummage the file cabinets and take it? Does it matter?
Your Honor, in that situation, I mean, yes, the answer is yes, it certainly would matter. And in that situation, that's of course not permissible. And that leads me to talk about something that's quite important to this case, which is the standard of review that we're employing here. When we are deferring to, or when we are considering the trial court's determinations of credibility or mixed questions of law and fact that turn on credibility determinations, we have to credit the trial court's credibility determinations. And the reason I'm talking about that, Judge McClure, is because here we do have conflicting testimony in our record about how Officer Tesfaye obtained this information. Officer Tesfaye testifies that he and Nurse Gomez had a pleasant exchange and it was quite friendly, and that she had ample opportunity to view the administrative warrant before she gave him the printout. And of course, Nurse Gomez testifies the opposite. And if her version of events is true, then that could definitely raise some valid constitutional concerns. But as I mentioned, when we're talking about who the trial court believed, when we have a he said, she said situation like we do in this case, and then we're thinking about who did the trial court believe, because because this court isn't equipped on a cold record to tell who's more believable, then we can infer from this record that because the trial court admitted this evidence, the trial court believed Officer Tesfaye. And so this court should believe Officer Tesfaye's version of events too. And when we do that, as we should, under the proper deference to the trial court's credibility determinations, then we see that Officer Tesfaye didn't obtain this information unlawfully. I will speak in a moment to the felony assault conviction, but I'd also like to talk about HIPAA because I believe it's quite important to the disposition of this case. Madam Presiding Judge, when you wrote the opinion in State versus Hardy, you explained that there are differing levels of privacy expectation depending on the different stages, as it were, of the blood draw process, or the defendant might have differing levels of privacy expectation. If it's the first stage, the blood draw itself, then that's of course a Fourth Amendment violation if the state conducts it, because that violates the defendant's sense of privacy in her body. The second stage is the actual testing where that occurs. And if the state performs that test, then that's also a Fourth Amendment violation. And in those first two stages, Your Honors, what we're talking about is the blood sample, not the result of the test. But in the third stage, we are talking about the results of the test. And the court held in Hardy that where the hospital has drawn blood for medical purposes and then the hospital has run that test, the defendant doesn't have a reasonable privacy expectation in the results of that test. And in Hughes, fast forwarding 20 years, Judge Urey, when you wrote that opinion, you explained that HIPAA didn't change the result of Hardy. So that's why HIPAA is not doesn't change the result of this case. With the time I have remaining, I'd like to talk about the felony assault conviction. And before I even talk about the definition of physical pain, that's quite instrumental to the 15th Court's holding below, I'd like to talk again momentarily about the standard of review, which again is quite important here. This court held in cases like Laster versus State from 2009 and Brooks versus State from 2010 that when we are reviewing evidentiary sufficiency questions, courts have to view the evidence in the light most favorable to the verdict. And they also have to, like with the trial court's credibility determinations, defer to the credibility determinations of the jury as well. Now, Your Honors, when we're talking about the definition of bodily injury, which is defined as physical pain, illness, and then any impairment of bodily condition. Here we're talking about physical pain. And this court said in Garcia versus State that, quote, any physical pain, however minor, can constitute sufficient pain to fit the definition of bodily injury.
Excuse me, is Garcia versus State cited in your brief?
Your Honor, I believe that it is. Yes, sir. Once or twice. We cited to Garcia. And also, Your Honors, as the courts of appeals have shown us, the intermediate courts of appeals, it's not even necessary for the victim to affirmatively say, yes, I suffered pain, for the jury to be able to infer that he suffered pain. Because as the Houston courts have said in cases like Aguilar versus State and Binfang versus State, jurors are reasonable people who are able to infer causes of pain and where it comes from. But Your Honors, in this record, we do have affirmative testimony that the officer experienced pain. In the face of quite aggressive cross-examination by defense counsel, Officer Testface was asked by defense counsel in the record at page 18, quote, did it cause you pain? And Officer Testface responded, quote, yes, it caused me pain. And because the victim doesn't even need to testify to affirmatively testify to an experienced pain for the jury to infer that pain existed, that's more than enough testimony under this court's standard to count as enough evidence to support the assault conviction on the physical pain grounds, especially when we're viewing the evidence in the light most favorable to the verdict and crediting the jury's credibility determinations as we must. Now, briefly, Your Honors, before I close, I'd like to address something about going back to the BAC information here. Even assuming for a moment that that was improperly admitted, we believe it was harmless error here because there's more than enough evidence in this record to demonstrate that Ms. Bluth was publicly intoxicated. We see in the record at page 27 that Ms. Bluth was standing on tables and waving her arms around and waving her margarita glass at people, and that she smelled quite strongly of alcohol amid other things. Your Honors, that's more than enough evidence to demonstrate, even without the BAC results, that she was publicly intoxicated. Now, Your Honors, in a few moments, counsel for the appellee may argue to this court that Ms. Bluth couldn't have given voluntary consent because she was too drunk. But this argument rather undercuts itself because if Ms. Bluth was too drunk to consent, then there's likely enough evidence in the record to support the conviction for public intoxication. That's part of why the court should reinstate the public intoxication conviction as well as the felony conviction, and why the court should reverse the 15th Court of Appeals.
Thank you, counsel.
Madam Presiding Judge, may I proceed?
You please.
Thank you. Your Honors, may it please the court. Good afternoon. My name is Christopher Royce, and along with my co-counsel, Ms. Daniela Bakulczyk, we're here today representing the appellee, Ms. Lucille Bluth, and we're asking this court to affirm the decision from the 15th Court of Appeals. Now, as my opposing counsel mentioned, there are 4 questions on appeal today. I'll be discussing with you questions 1 and 2, specifically how the governor's 3rd and 4th emergency orders preempted the order of Orange County And Ms. Vakulchek will be discussing questions 3 and 4, dealing with the unlawfully BAC results and the legal insufficiency for the charge of felony assault. Your Honors, the state of Texas in modern times has not faced a disaster quite like the COVID-19 pandemic. However, when it comes to our state's general disaster response, it's the job of the legislature and the legislature alone to determine what powers are delegated to who. Now, today, as we review the decisions of the Texas governor around this time of last year, the governor was simply acting under those statutorily granted powers, and he did not exceed his authority in today's case. There are 2 reasons why that rings true. First, the governor is not required to include his rationale in his third order, and it can be implied given the circumstances. And second,
Counsel, I'm sorry, I have a question about that. The governor didn't supply his rationale, and the statute arguably does not require him to do so. But as a practical matter, how is this court to review the propriety of his determination without some indication of why he made the decision to execute that order?
So, yes, Your Honor. So again, we agree with you about the statute of the language, that there's no statutory language requiring this hindrance. But to answer your question specifically, I would argue that what Judges Hervey and Walker mentioned earlier is what this court needs to do, and look at the totality of the circumstances and the previous orders that were made by the governor, as well as the circumstances of the time that actual proclamation was signed.
But if we hold that, aren't we basically just giving the governor carte blanche until somebody comes to court? Like, he's just going to do whatever he wants, right?
Your Honor, we would disagree that that is the case. And we believe that the governor's actions are going to be, has to be still subject to that condition, because we completely agree. So when it's judicial review, we have to understand if it actually met that condition. So we don't believe that he's just going to have this all out there authority, because he still have to be reviewed whether or not he met the actual condition. However, what our argument here today is that that rationale just doesn't have to be explicit in the language. And here, implicitly, we can understand what that anti-hindrance rationale actually was. And so now
So what will we use to kind of latch on to Judge McClure's question? What would we use to measure this? Would we look to other states and their orders? Would we look to the federal government? I mean, what can we actually use to benefit us in a review of these things?
Your Honor, we would urge this court to look at the circumstances of Texas at the time of the proclamation. Now, this principle was discussed by the Texas Supreme Court in the case of Abbott versus Anti-Defamation League. Now, this case was decided throughout using the COVID-19 pandemic, and the governor there was using this same power, 418.016. And there, what the part of the court's analysis said was that at any time that the governor makes a proclamation under this Texas Disaster Act, he has a variety of competing considerations to take into account. And so we're asking this court to defer to that decision. And that makes sense here, as every time the governor made the proclamation, he had to take into account considerations of the economy, the health of Texas citizens, as well as the individual rights of his citizens. Now,
but what about the considerations of the counties themselves?
So yes, Your Honor, that's actually a great question. Opposing counsel touched on that. And I would urge this court to notice that under the Texas Disaster Act, there's a difference in language of a local disaster and a statewide disaster. Now, that distinction has already been discussed by the 8th Court of Appeals in the case of State versus El Paso County. Now, there it stated that surely these judges can control a local disaster, such as a hurricane or something of that sort. But when we're looking at a statewide disaster, which is what we're dealing with here, there has to be one individual who is the captain of the ship or the final decision maker, as that court puts it. What the legislature entrusted that individual to be is the governor, which is why
that the governor's decision in this type of a circumstance should be reviewed essentially politically, that if the people don't like it, the people won't vote for him. And if the people do like it, well, then maybe they'll give him a new term in office. Is that what you're saying?
No, Your Honor, we would not argue that that's the political reasons is the only thing. However, what we argue is that the governor, anytime he makes a proclamation, has a number of reasons for suspending a statute, and he's allowed to. So long as one of those reasons is related to anti-hindrance response, he's met the condition under 418.016. And so that makes clear when we look at the statutory language and apply the canons of construction. So we've talked about this provision. I want to now give the actual language of it, as I think that'll help guide our discussion. The statute states that the governor may suspend the provisions of any regulatory statute if strict compliance with the provision, rules, or order would in any way prevent, hinder, or delay necessary action in coping with the disaster. And so when we apply the canons of construction, first, as Judge Erie pointed out today, as he's pointed out numerous times today, that procedure requirement is not in the language here of that there must be an explicit anti-hindrance rationale. What opposing counsel?
Counsel,
Go ahead.
thank you. I have a question for you. The appellant didn't mention this, but I'm wondering if you happen to be aware of any cases where we have imposed a disclosure requirement where one was not articulated in the statute.
No, Your Honor, I'm not aware of such a case at this time. In fact, I would actually argue that when we look at different provisions and different acts, adding the procedural requirement in this case would go against what the Texas Disaster Act actually does. So what I mean by that is when we apply the canons of construction, we also have to look at what provisions are not included. And what I mean by that is that the Supreme Court noted this in Digital Reality Trust versus Somers, but when certain language or provisions is in one part of the statute and omitted from another, well, we have to presume that the legislature did so intentionally. In another part of the Texas Disaster Act, when the governor has to declare a disaster, there is a list of procedural requirements that must be included in that proclamation. Now, in 418.016, those procedural requirements are not there. The procedural requirement that opposing counsel is asking of is not there. So what opposing counsel was essentially asking is for this court to take the role of the legislature. And we can see that the recent pandemic may have pointed out some flaws in this Texas Disaster Act. However, that's something that the legislature would have to amend in future sessions, because when we're reviewing the governor's actions here, it's what the Texas Disaster Act was in June of last year. And here he acted well within his authority in not including his rationale. And so,
how would you define, Mr. Ruiz, a regulatory statute, and what should we look to define that?
So yes, Your Honor. So we concede that the term regulatory statute is not defined in anywhere in the Texas Disaster Act. However, we believe that when it deals with state business, that's what the court in State versus El Paso County discussed, then that's what the definition that we should apply. And so when we look at penal statutes, it's completely okay for a statute to be regulatory and penal in nature. And here we understand that it classifies a crime as a Class B misdemeanor, but it's regulatory here because it deals with the state business, specifically how local governments are supposed to interact and deal with the violation of one of their orders. So I understand that's not as clear of a definition, but when we dealing with state businesses, whether that's through the agencies or of a whole, that term has been expanded in its definition, and we would urge this court to adopt that definition as from the 8th Court of Appeals.
The state business is county business?
Yes, Your Honor. Again, so what that term was expanded not to just mean what the actual business of itself, it was expanded to include different parts of the state and how they all interact with each other, especially here when we're dealing with a disaster response. So yes, Your Honor, that would include the county business here in today's case. And so now I want to now talk about I want to now move on to the fourth issue in today's, or the second issue in today's case regarding the governor's fourth order. If you remember, that deals with the pardon clause. As opposing counsel argued that the governor's fourth order was actually a commutation. Now, this court must rule to the contrary for two main reasons. It ignores the language of the Texas Constitution, specifically the term after conviction. And second, the fourth order applied generally, not to individuals, meaning that what opposing counsel was asking us to do is change everything we know about what a pardon and commutation actually is. And so let's look at the language now of the actual governor's power, clemency power. And this is stated in Article 4, Section 11. And it states there that the governor shall have power after conviction to grant commutations of punishment and pardons. Now, that term after conviction is what this court should defer to here today, because at the time of the fourth order, Ms. Bluth had been arrested, she'd been indicted, but she had not been arrested. Now that timeline is discussed on page 9 of the record, but because Ms. Bluth had not been convicted, the governor's clemency power could not have been implicated. And so when we look at how that may be, well, this court has defined the term after conviction differently over time. We understand that. At one point, it meant final conviction. But with the current definition now, as made clear in this court in Ex parte Giles, after conviction means at any point in the appellate process after the jury has made an initial determination of guilt. Well, here, no jury has made a determination of Ms. Bluth's guilt. So how can we deal with a pardon clause or clemency power when there's been no conviction here? And this actually makes sense when we look at the characteristics of typically what a commutation actually is, because a commutation applies to individuals, to the individual. It takes into consideration the characteristics of each defendant. And so what I mean by that is that with the governor and the Board of Pardons and Paroles deal with the clemency power, and they're supposed to take into consideration all of those factors and decide whether or not to issue that pardon or commutation. Here today, I would urge this court to look at the language of the fourth emergency order. That's on page 6 of the record. And it states that it applies to all counties and to apply to all action on or after the effective date. That applies generally to all individuals. That doesn't just apply to one person. So opposing counsel's argument, again, tries to change what we know about the governor's clemency power entirely. And so now to sum up this argument, I would urge this court to look at Judge Newell's decision in Van Dyke versus State. Specifically, there's one sentence and it states that the executive has the authority to grant clemency, and they have the authority to grant clemency after the individual is convicted based upon the individual characteristics of each defendant. Here, Ms. Bluth had not been convicted, and the fourth order did not take into consideration her characteristics. Therefore, the governor's pardon power was not implicated, whether it be a pardon or a commutation. And as a result, the governor validly suspended section 81.087. And so now that we've discussed this a little bit, I want to respond to opposing counsel's underlying principle in today's case. And that's that when a local order and a governor talk and they disagree about how disasters should be interacting with one another, well, that we should defer to the local county health judge. Your Honor, we cannot allow for this court to rule in that favor here today. The governor was entrusted in the Texas Disaster Act to be that final decision maker. They're the ones that are supposed to make these expeditious decisions when we deal with disaster response. The issue here today is with the Texas Disaster Act. If we wanted a slow decision-making process, we wouldn't need to change anything at all. The legislature is already entrusted with doing that and changing the law as it goes. But when we're dealing with disasters, whether it be hurricane relief or COVID-19 response, we should entrust the governor to make these decisions as the science is coming in, as we're learning about what we're dealing with. Here, that's simply all the governor was doing. He was making expeditious decisions as he was learning about the pandemic at the time. He was, at this point with Ms. Bluth, he was taking into consideration that there were calls for protest. He was taking into consideration that the science behind efficacy of masks had not been fully developed. And finally, he was taking into consideration the fact that local government and the actual governor, when they disagreed with one another, well, the legal implications were not entirely clear.
Counsel, as the appellant pointed out, the pandemic affected different parts of the state differently. Wouldn't a county judge be in the best position to determine what would be best for that particular county?
So, Your Honor, we would disagree with that statement, because essentially what that allows is that in this statewide disaster, 254 different counties can respond in different ways. An individual could be in Fort Worth and have one regulation where Dallas could have the opposite. So we believe that local county judges can have control when the governor doesn't speak on the issue. However, when he does, he's the final decision maker. That's what the statutory language tells us. And so, Your Honor, it's for those foregoing reasons, we're asking this court to affirm the decision from the lower court. Thank you for your time.
Thank you, counsel.
Presiding Judge and Your Honors, may it please the court. My name is Daniela Vakulchik, and I represent the appellee, Ms. Lucille Bluth. As my co-counsel mentioned, I will be discussing how the trial court improperly admitted the appellee's unredacted blood alcohol concentration results,
as well as how the evidence is legally insufficient to sustain the conviction of felony assault. We ask the court to affirm the decisions of the court below, and there are 2 reasons to find in favor of the appellee regarding these 2 issues. First, due to a reasonable expectation of privacy, as well as the inapplicability of the third-party doctrine, the Fourth Amendment is implicated and violated here, and the BAC results should have been suppressed at trial.
Counsel, didn't your client consent to the blood draw?
Well, Your Honor, to that I make 2 points. First, even if this court were to find that the trial judge, even if this court were to defer to the trial judge's implicit finding of fact that the appellee did consent to her blood draw, the third-party doctrine still does not matter. And ultimately, she still has a subjective expectation of privacy in her BAC results, contrary to what my opposing counsel stated. For under the privacy theory as laid out in State v. Martinez, a decision written by Judge Walker, an individual has standing to contend that a search or seizure was unreasonable if they first have a subjective expectation of privacy. Now, my opposing counsel states that because the appellee consented to her blood being drawn and tested by medical personnel, she then relinquished her expectation of privacy in that result, in those informations from government obtaining that information. But that is not how the Fourth Amendment or the privacy theory operates.
Well, counsel, wasn't it the hospital, the nurse at the hospital who disclosed the information to law enforcement?
Yes, Your Honor. And this would typically implicate the third-party doctrine. However, the third-party doctrine is inapplicable here for 2 separate reasons. Now, my opposing counsel shows that the third-party doctrine typically involves a transfer of information from an individual voluntarily to a third party, and then that third party voluntarily to the government. Here, even if this court were to defer to the trial court's implicit finding of fact that the appellee voluntarily handed over the information to this third party, that does not mean the third party doctrine applies. And that's because this is in the medical context. See, in reviewing a decision of a court of appeals, this court in Richardson v. State found that that court of appeals in that case erroneously believed that that any voluntary disclosure of information will destroy a reasonable expectation of privacy to that information. See, that a court of appeals found that an individual assumes the risk of further disclosure when they, in fact, disclose information to a third party. But this court disagreed and stated that whether an individual assumes the risk that a more limited disclosure will, in fact, open the door to a public disclosure depends. It depends on the reasonableness of his subjective expectation of privacy that the information is to remain confidential. See, this court found that there are circumstances in which even a disclosure of information should remain confidential because of a unilateral or mutual understanding that it is to remain private. Under HIPAA and the Texas Medical Practices Act, there is clearly a mutual understanding that this information was to remain confidential even when disclosed to the third party, Nurse Gomez. See, in Carpenter v. United States, a seminal case for the third-party doctrine, Justice Gorsuch dissented and noted that the third-party doctrine has been criticized since its inception. In fact, the justice stated that people often do reasonably expect that that information they entrust to a third party will still remain private, particularly when subject to confidentiality agreements or statutes such as HIPAA and the TMPA. In fact, in just September, the El Paso Court of Appeals used this note from Justice Gorsuch to find that the third-party doctrine alone cannot defeat a reasonable expectation of privacy in historical cell phone tower information. And then in March of 2020, this court found in Holder v. State, as Judge Hervey wrote, that the third-party doctrine also is not enough to defeat a reasonable expectation of privacy in historical CSLI information. In Richardson itself, this court stated that, quote, "We would not want to say, for example, that society does not recognize the confidentiality of information imparted to one's physician. The most common instance in which disclosure may still be protected from a third-party doctrine is in medical instances such as this one. Therefore, the third-party doctrine does not apply because the appellee still had a reasonable subjective expectation of privacy in that information, even after it was voluntarily disclosed to the third party.
Well, counsel, even without the information, say that we agree with you that it was improperly disclosed, isn't there sufficient evidence to find that your client was intoxicated?
No, Your Honor. Taking a look at the record, the BAC results carried a lot of weight at trial, and the jury certainly could not have found beyond a reasonable doubt that the appellee was publicly intoxicated without these BAC results, and therefore this is harmful error. And this panel certainly could not find that this jury, beyond a reasonable doubt, would have found the appellee to be publicly intoxicated. And at the most, this should be remanded for a new trial where the BAC results should have been suppressed. As my opposing counsel mentioned, in State v. Hardy, a Texas Court of Criminal Appeals case in which presiding Judge Keller wrote the opinion, this court identified 3 stages of blood evidence in which the state may act with varying expectations of privacy. And in that case, this court found that there is a lower expectation of privacy in stage 3 blood results. But this does not mean there is no expectation of privacy.
Does the record that you have reflect that the prosecution argued the intoxication in their closing arguments, or is it part of the record in this proceeding?
I'm sorry, Your Honor, I don't quite understand your question. Could you repeat it for me?
In the closing arguments, the record that you were provided for this proceeding, are the closing arguments contained that you're able to review? And if they were, does the record reflect that the state relied heavily upon the intoxication to make their case?
Your Honor, I do not have a record in which closing arguments are contained within. However, taking a look at the record, there is minimal information to indicate that the appellee was publicly intoxicated besides the BAC results. And I believe this is further evidenced by the fact that the officer did not bring charges of public intoxication until after he himself saw the BAC results. And as he was at the bar as well, and he saw that the appellee was at the bar, was aggressive, was dancing on a table, and yet still chose not to charge her for public intoxication at this point. Now, this
Counselor, I mean, in just a few brief breaths, you basically said that there was not other evidence of intoxication, or at least sufficient evidence of intoxication, but you just kind of gave us a laundry list of certain factors that were a part of the trial. You do concede that dancing on a stage, having bloodshot eyes, smelling of alcohol. I think his testimony was that it was so much that her breath smelled like she drank a pint of tequila or something of that nature. Is that not enough for being able to possibly determine that she was intoxicated?
No, Your Honor, at least not beyond a reasonable doubt. Taking a look at the evidence, this court, as well as myself, can come up with different theories for why the appellee was dancing, why she smelled like alcohol in a bar, and otherwise. And this all goes to show.
And is mere intoxication enough to prove it public intoxication? Doesn't it take more than that?
Well, and correct, Your Honor. And the evidence does not support, aside from the BAC results, that the appellee was intoxicated enough to sustain the charge for public intoxication. And therefore, at the most, the correct remedy would be to remand for a new trial, suppressing the BAC results. Because the appellee had a reasonable expectation of privacy in these results, and the third-party doctrine doesn't apply because of that reasonable expectation as well. But there's also a second reason why this third-party doctrine does not apply. And that is because the third party must voluntarily hand over the information to the government. To do so otherwise would render this third party an instrument of the government, which is impermissible, as shown in Skinner v. Railway Lab Executives Association. Now, even if this court were to defer to the trial court's implicit finding of fact that the nurse was not pressured by the officer and did accidentally hand over the unredacted blood alcohol concentration results, that still does not mean she voluntarily handed over those results. This is because Bouvier Law Dictionary tells us that an involuntary action is done without the independent will to act or without knowledge of doing so. Now, page 26 of the record shows us that the dissent in the lower court, as well as the state, even admit that what the nurse did here was an accident. Well, Bouvier Law Dictionary and common sense tell us that an inadvertent error is done without knowledge of that error, therefore is involuntary. And I would urge the court to find this less broader construction of what voluntary means under the purposes of the third-party doctrine.
Well, Counsel, shouldn't we look at the understanding from the officer's perspective? If he's being handed this information by the nurse, then why are we examining whether the nurse's actions were voluntary or involuntary?
Because, Your Honor, even if the officer himself did not coerce the nurse into handing over the results, because there are Fourth Amendment protections on this BAC results, obtaining this information and using it at trial by the state is a violation of the Fourth Amendment because there was no warrant. See, this is a Fourth Amendment protected piece of information, and because of the inapplicability of the third-party doctrine, a warrant is required to use this evidence at trial. Because the state failed to receive a warrant, the third-party doctrine does not apply, and the appellee certainly had a reasonable societal and subjective expectation of privacy in these BAC results. They should have not been used at trial. Therefore, the appellee should be acquitted of the charge of public intoxication. Furthermore, the appellee should be acquitted of the charge of felony assault on a public servant. Now, before I discuss this issue, I want to make something clear. The actions of the appellee towards the officer, who was simply doing his duty, were wrong, disrespectful, and offensive, particularly in the midst of this global pandemic. But that's not the question here. The question is whether her actions constitute a felony assault, and they don't.
Excuse me. I want to ask you about the penal laws pertaining to subjecting someone to AIDS. And there are there were penalties for the possibility of subjecting someone to AIDS. So I'm comparing that to subjecting this officer to COVID by coughing on him. How do you respond?
Well, Your Honor, as found in Weeks v. State, to use illness as the theory for bodily injury, either for assault or attempt of assault, the state must prove beyond a reasonable doubt that the individual knew that they were infected with the disease and knew that it was transmittable. As shown by the record, the appellee had no knowledge that she was infected with COVID-19 at the time, and therefore the theory of illness for bodily injury fails under this test. A legal sufficient.
I just wonder whether the same rule would apply. I mean, I think you could argue that it's reckless. I mean, is that not a possible argument that might sustain Judge Herbie's position is?
No, Your Honor, because for the requisite mental state of recklessness, which is a minimum for assault, the state would have to prove that the appellee was aware of the danger, which for illness would need to prove that the appellee was aware that she had COVID-19. To do so otherwise, particularly because she was showing symptoms of illness, would only meet the requisite mental state of negligence, which is not an appropriate mental state for the crime of assault. It is also legally insufficient to sustain the charge of felony assault due to the face mask snapping. This is because a bare assertion by an officer that he suffered pain without more corroborating evidence is not enough to satisfy the evidentiary requirement, as found in Ortega v. State, a Texas Court of Appeals case in which this court denied petition for review. Now, importantly, to be guilty of assault, one must intend the result of the conduct and not simply the conduct itself. Here, it is conceded that the appellee intended the conduct in which she exemplified, which is pulling a face mask and snapping it back. However, it cannot be shown that she intended the result of physical pain, illness, or impairment of physical condition, which is required for bodily injury, by simply pulling a soft cloth face mask and releasing it back into the officer's face from a close distance. Now, alternatively, this court has the option to reform to a lesser included in most cases. However, the only lesser included that would apply to this case is criminal attempt to commit offense, but that implicates a higher requisite mental state, specifically specific intent. And the court has failed to show even recklessness for assault either by the face mask snapping or coughing into the officer's face, and therefore has failed to show specific intent. For the foregoing reasons, we respectfully ask the court to affirm the decisions of the court below. Thank you.
Well, Mr. Volch, ma'am, just real quick question. You're asking us to affirm what the Court of Appeals did, but didn't they actually find and determine that it didn't, that elements weren't met because they said that there wasn't significant pain, that there wasn't enough evidence to determine that there was significant pain. And it seems to be that you're making kind of a different argument here today. Do you agree with that?
No, Your Honor. What I'm arguing is both that the appellee did not have the requisite mental state, as well as the element of bodily injury has not been satisfied here, particularly because the evidentiary requirement requires some corroborating evidence, such as a corroborating witness or photo. Presiding Judge, I see I'm out of time. May I briefly answer the question?
Yes, please.
Thank you, Your Honor. See, Your Honor, the evidence here for bodily injury has not been satisfied because of the lack of corroborating evidence. Furthermore, the state has failed to prove the requisite mental state for both assault as well as attempt of assault. Thank you, Your Honors.
Thank you, counsel.
May it please the court, 2 points on rebuttal. Judge Geary, you asked opposing counsel when discussing the Texas Disaster Act, how the court was supposed to review the propriety of the governor's statutory suspensions if he never has to say his reason. The short answer to that, Your Honor, is that the court can't. And to answer Judge McClure's question to opposing counsel, yes, that does grant the governor carte blanche to essentially do whatever he wants. I'd like the court to think about the implications of what the appellee is saying. Under the Disaster Act, the governor can unilaterally suspend statutes, and then he can also unilaterally declare states of disaster, and then he can unilaterally suspend statutes. And while the legislature can overturn those states of disaster, the legislature wasn't in session during the events of this case. And that's why we're asking this court to require the governor to interpret the statute to require the governor to at least say what his purpose is in suspending the statute.
Nobody contests, though, that there was a state of emergency. Is that right? That's conceded.
Your Honor, we don't contest that, no. Our second point on rebuttal is that opposing counsel said that there's not enough evidence to show that Ms. Bluth was publicly intoxicated beyond a reasonable doubt. We'll point out preliminarily that what opposing counsel is doing is saying that the jury couldn't possibly, opposing counsel is contesting the findings of the jury and saying that the jury and not viewing the evidence in the light most favorable to the verdict, as this court must do. And Your Honors, in the record at page 27, as I mentioned earlier in my argument, we do see that there's plenty of evidence to support the public intoxication conviction. She was swinging her arms and standing on tables and being quite belligerent, as the record states. So there is enough evidence to support the public intoxication.
But wouldn't those things indicate or support the fact that she's just an activist?
Madam Presiding Judge, I see that my time's expired. May I answer Judge Hervey's question and then conclude?
Yes, please.
Judge Hervey, we don't believe so when reviewing all the evidence together. When we see that she also had glassy bloodshot eyes and that she smelled like alcohol, and Officer Tesfaye testified that she smelled, that she, that he testified all of these things, and that we have all this evidence in our record showing that she was intoxicated in public, and that when she's waving her arms around, she's probably a danger to other people. This doesn't suggest just the behavior of an activist. It's for these reasons we ask the court to reverse.
Thank you, counsel.
Okay, so judges, I believe now you turn off your camera so that you can fill out your ballots.
Could y'all open the room back up so I can actually use my computer? I'm trying to switch to my computer. I've been on my phone this whole time, and it won't let me log into Zoom because it says that someone has closed this room. Or
Okay, let me ask Ashley.
Your Honor, I just took care of that. We locked the room so that we didn't get people coming into the room. You can go ahead and come in with your other computer now. I'll lock it after you're in.
Okay, thank you.
So, how do we do? Are we just covering up the image, or is there some way to close this out? Because I got here late on the instructions.
If you just click the icon at the bottom of the screen where it says stop video,
yeah,
it's like a video camera. That'll just turn your camera off. Perfect.
Okay, so how do I'm not able to get to the ballot. Where? Oh, no. Uh,
How do I get to the ballot?
yeah.
There's a link. She gave you a link in the chat, but also there's one in your email from Sharon
Yeah.
last Friday.
And I tried to get into that off my phone and I can't do it.
Oh,
Yeah, you have to go onto your work email and there's a hyperlink to the word ballot that'll let you do it.
I know, but I tried to do that on my phone and it won't open. I mean, it shows me the ballot, but it won't let me enter anything.
Well, no, they attached the PDF of the ballot, but there's in the text of the email, in the content of the email itself that Sharon sent, there's just a word ballot is underlined. And if you click on the word ballot, that opens a web browser and allows you to enter the thing.
Okay. Well,
Okay, everyone, if you just give me a moment, I'm going to send you another link to the ballot.
I already got
Give me a moment, I'll take care of that.
oh, I see it.
think
I
I
see
volunteered
ballot.
information over to a third party.
I got it now.
Okay.
What is going on here? Mm-mm. It is not letting me do anything.
Yeah, and I'm not seeing it now that I've switched over to my
It'll only let me put my name in and then it won't let me enter anything else.
Was the appellant the 105 or 102?
Yes, 105.
And the other one?
It is.
I'll
It
look
is